We will.
Yeah.
Okay, thank you.
You're welcome. So just a couple housekeeping things. Restrooms are outside to the right. Just double check your cell phones, okay? It's a good time to double check your cell phones, okay? We'll get started in like 2 minutes. So would everyone please rise? Y'all know when Judge Marcy were presiding, you may be seated.
Good morning, everyone. Good morning.
So this is CB 2511089. The case is captioned the City of Cleveland versus the Haslam Sports Group, LLC.
All right, City of Cleveland versus Haslam Sports. Representing the City of Cleveland?
Good morning, Your Honor. Justin Herdman, Jones Day, on behalf of the City of Cleveland.
Your Honor, Mark Griffin, Quad Director of the City of Cleveland.
Good morning, Your Honor. Tracy Stratford from Jones Day on behalf of the City of Cleveland.
Good morning. Representing Haslam Sports Group?
Good morning, Your Honor. Robert Ware, Thompson Hine. With me at the table, Anita Reddy, Bill Savitt, Brad Wilson, who will be presenting today.
Thank you so much. All right, so we'll get right into it. So this is a motion to stay, motion to dismiss. Okay, would you like to present an opening statement?
Good morning, Your Honor. May it please the court.
Sorry, can I just get your name one more time?
Yes, I was just going to say William Savitt, which is S-A-V-I-T-T, from the Wachtell Lipton firm, and we're here on behalf of the Haslam Sports Group. Thank you, Your Honor, for hearing us this morning. We're here, as the court's just noted, on our motion to stay or alternatively dismiss the complaint that's been filed here. The court has generously set down this time for argument, and we'd hope to use our time with you, Your Honor, to highlight important points of factual background and then discuss the legal issues that are presented upon the motion in front of the court. Above all, Your Honor, we want to be available to address any questions that the court might have regarding the papers that we and our friends on the other side have filed and that the court views as important in considering the questions here presented. With the court's permission, as we've previewed, we propose to proceed as follows. My partner, Anita Reddy, will discuss concisely issues related to the factual background of the case, and my partner, Mr. Wilson, in the very sharp royal blue seat in the second row, is going to talk about some of the legal issues that are front and center in our motion. And if necessary and sensible, I'll present rebuttal argument after our friends on the other side have had the chance to chat with the court. Before ceding the podium to the other side and then Ms. Reddy, let me offer a few words by way of brief introduction. This lawsuit, as the court knows, concerns the future of the Cleveland Browns football club. The Browns have a lease to play their home games at Huntington Bank Field, just a block or two away by the lakefront, through the end of the 2028 NFL season, and they have committed to honoring that commitment, and honor that commitment the Browns will. The club is pursuing plans to build a state-of-the-art domed facility in Brook Park as the team's new home after the lease expires in 2029. Those plans anticipate a massive investment in Northeast Ohio, one that promises extraordinary economic returns for the city of Cleveland, for the county, and, Your Honor, for the state, all reinforcing the steadfast commitment of this team and its ownership to Cleveland and the broader Cleveland community. Now, when in the order of a year ago, the city and certain officials associated with it said they wanted to stop the Browns from considering the Brook Park alternative and continued to refuse to present any plausible plans for developing or renovating the lakefront facility, the Browns filed a lawsuit in the federal district court in the Northern District of Ohio, right here in Cleveland, seeking a ruling that they were permitted to move. That was in October 2024. And that lawsuit, as the court knows and the court will hear, turns on issues, among other things, centrally arising under the United States Constitution, the federal Constitution. Months later, the city filed this lawsuit in this court, almost 3 months later, and as the court has read and as the court will hear, the second filed suit pending in front of Your Honor concerns, broadly speaking, nearly identically speaking, the same facts and the same legal issues as the earlier filed suit that the team filed in the federal district court. Our motion, Your Honor, seeks simple relief: stay this action in favor of the prior pending federal action. And that's to avoid inefficiency and wasteful duplication, and to ensure that determinative questions of federal constitutional law are determined by a federal court. And above all of that, to avoid an unnecessary collision between two courts, both of competent jurisdiction. Now, the city tells the court not to bother with the federal court. That court, you've been told, lacks jurisdiction. Whether the federal court lacks jurisdiction is not for the city to say, it's for the court to say, for the federal court to say, and Judge Ruiz certainly hasn't indicated that he thinks he lacks jurisdiction. To the contrary, when the city, in a continuing effort to avoid progress in the federal court, tried to stop the Browns even from amending their complaint, it told the federal court that it lacked jurisdiction to even consider the request to amend. Now, Judge Ruiz was having none of that argument, Your Honor. He issued a memorandum opinion because the city's motion required the drafting of an opinion, and an accompanying order that granted leave and green-lighted the Browns amendment in the federal court. And as you'll hear, the federal court has taken further action to move that federal case along while the city does its level best to stop progress in the federal court, where the first filed suit is pending and where the federal constitutional claims belong. Your Honor, we'll have a lot to say later on the merits, but that's not for today. We think the merits are overwhelmingly in our favor, but that's not for today. The issue for today is different, and it's narrower. It's whether this dispute should be litigated in one court or in two courts at the same time. Whether it should be litigated in a way that's designed to promote efficient decision-making or in a way that's designed to waste the court's time and the party's money. It's whether the dispute centering on federal constitutional issues should proceed in federal court. It's whether the first filed action should proceed first, or alternatively, as my friends on the other side would have it, to force an inevitable collision between courts and the likelihood, or at least the substantial possibility, of conflicting rulings, all of which, as the court well knows, fly in the face of basic principles of judicial economy. We think there's only one possible answer here, Your Honor, the one rooted in judicial economy, the one rooted in principles of comity, the one that speaks common sense. The first filed case goes first in the court that first seized the matter jurisdictionally, and in a federal court where thorny questions of federal constitutional laws can be sorted out. Those are our introductory remarks, for Your Honor, and we appreciate your patience with them. I think the order of operations we discussed was that we cede the podium to the other side for an introduction. I'm happy to do that, and after that, Ms. Reddy, my partner, will come up. We had some slides, which might be on the screen, but with the court's permission, we wanted to hand them up to Your Honor and staff, and I think we've already shared them with the folks on the other side.
Thank you.
Thank you, Your Honor. May I?
Yes. Thank you, Your
Good morning, Your Honor.
Honor.
Again, Justin Herdman on behalf of the City of Cleveland. And I will be brief here. I know we've got a lot to get to this morning. I just, in terms of introductory remarks, I will save most of what I have for response here to what my friends on the other side have to say. What I would say at the outset here is I would just offer this for the court. All of this on this side of the courtroom, every single person that's here, every slide that you're about to see, every ounce of effort that has gone into this presentation and this argument that you're about to hear, Your Honor, all of that is designed to do one simple thing. None of these folks ever want to walk back into this courtroom ever again after today. That is what this is all about. They don't want to be here. The Cleveland Browns do not want to be in an Ohio court with this dispute. That's what this is all designed to do. They don't want to have an Ohio court sit in judgment of this dispute. That's what this entire issue is about. And the City of Cleveland's position is the only place that this dispute should be is in an Ohio court. These are not overlapping cases, first of all. They're just not. When have you ever had an Ohio citizen come before an Ohio court with respect to a dispute on an Ohio lease with an Ohio municipality and say that there's a federal question that has to be decided before this court can sit in judgment of that lease dispute? That's exactly what the Browns just told you, Judge. The City of Cleveland is the landlord of the Cleveland Browns at Huntington Bank Field. We have a breach of contract claim that we have brought in a well-pled complaint that's before this court. There is not a single thing pending in that federal court case that is going to determine that breach of contract claim. I'll get to that later, but that is a simple fact that they cannot argue their way around. They're not going to be able to say anything about how that federal court case is going to touch that simple breach of contract claim. It is a lease dispute. They are currently violating their lease. They are breaching their lease. They are in current breach of their lease. They are violating Ohio law as well. That's why we're here. That's why we brought this case. And I'll have more to say about the posture of the federal court cases. There's not a lot to say about it other than keep this in mind. They are not the first filed case. Their complaint, their current complaint in federal court, was filed on Memorial Day, a month ago. So yes, they filed in October, but they're on their third complaint in federal court. It is a contorted procedural morass in federal court of their own making. But let's not pretend like this is some clean, pristine silver bullet of a complaint that they filed in federal court. It has been a procedural mess, and it remains so. And their first filed complaint, as they would put it, was filed 5 months later than our complaint that's been filed here and pending in front of Your Honor since January. So I'll have more to say, Your Honor, but that's where I wanted to start off, is we're here in front of you. We think that this case belongs in Cuyahoga County, where Huntington Bank Field sits, where the Cleveland Browns have played for the last 25 years, where the City of Cleveland, the landlord of the Cleveland Browns, is, where this courthouse sits. We think that an Ohio State Court judge Judge Lawrence Seymour should be sitting in judgment of this dispute, should be interpreting Ohio law, and should be sitting in judgment of these claims that we have brought. And I'll have more to say about that later, but that's what I have to say in opening, Your Honor. Thank you.
Thank you so much. Ms. Ray?
Good morning, Your Honor. This dispute is about the Browns' ability to call a new stadium home when their current lease expires in 2029, and the city's ability to use the Modell law to try to stop them. The history of the Browns' present lease and of the Modell law actually begins with another lease, and we think that history is important, Your Honor, to understanding both the current lease and the Modell law. In 1973, the Browns entered into a lease with the city to play in Municipal Stadium. As I expect you know, the team was then owned by Art Modell. That lease obligated the Browns to play their home season games in Municipal Stadium for 25 years, until 1998. But in 1995, with 3 years still left on the lease, Mr. Modell decided to move the team to Baltimore, to fill a hole left by the Colts, who had moved to Indianapolis. And the city sued Mr. Modell and the Browns for breach of the lease. They moved for a preliminary injunction. The city claimed it was entitled to specific performance. The Browns couldn't just pay for the remainder of the lease, the city said. The Browns had to play in Municipal Stadium for the remainder of the lease. As the city argued in its PI brief, to allow the Browns to repudiate the lease agreement 3 years before its expiration would deny the city the essential benefit of its bargain. The city settled that suit in 1996 in a three-way deal with Mr. Modell and the NFL. And that deal included the Browns' present lease, the one that is at issue today. Under that deal, Mr. Modell was allowed to move the team to Baltimore, but in exchange he had to leave behind the Browns' name, their colors, record, and history, which would be carried on by a new franchise. And in exchange for the NFL's authorization for a new Browns franchise in Cleveland, the city agreed to build a new stadium, partly funded by the NFL, that would be leased to that new Browns franchise. And although that stadium would be owned by the city, the cost of constructing it would be shared with the NFL, and the cost of maintaining it would be shared with the new Browns franchise. That settlement bargain was documented in several contracts related: a franchise agreement, a financing agreement, and a lease agreement. The lease agreement, dated April 26, 1996, governs the Browns' lease of the new stadium, the stadium we all know today as Huntington Bank Field. The city, as the owner of the new stadium, was party to that lease as the lessor, and because the new Browns franchise did not yet have an owner, the NFL executed that lease on behalf of the new owner as nominee for the new owner. And in 1998, when Al Lerner bought that new Browns franchise, as required by the lease agreement, the new franchise then assumed that lease. The lease agreement sets a lease term of 30 years. That term runs from the new franchise's first season in the NFL. That first season began in the fall of 1999, so the Browns' current lease expires on February 1st, 2029. The lease agreement, like other lease agreements, imposes mutual obligations on the parties during the lease term. During the lease term, the city is obligated to fund specified capital repairs. The Browns owner, on the other hand, is obligated to pay for stadium alterations or improvements, for routine maintenance, and annual rent. And during the lease term, the Browns are obligated to play all regular season home games and postseason games in the new stadium, and at least half of their preseason games there. Now, the lease agreement does not give the city a right to extend the 30-year lease term. And the lease agreement expressly provides that upon expiration of the term, the Browns, and I'm quoting the lease, Your Honor, must peaceably and quietly leave, surrender, or yield up unto the city the leased premises.
I'm sorry, would you repeat
At the end of the term, the contract requires that the Browns peaceably and quietly leave, surrender or yield up unto the city the leased premises. The leased premises are the stadium, Your Honor. Now, in June 1996, a few months after the settlement of the city suit, the General Assembly enacted Section 9.67 of the revised code. But no one calls it that, Your Honor. Everyone calls it the Modell Law because it was passed as a legislative rebuke to the move that Mr. Modell had tried, breaking the Browns' lease of the stadium, supported by public money, years before the lease expired, to take the team to another state. Now, the Modell Law prohibits an owner of a professional sports team from moving the team from a tax-supported home stadium unless the owner either has an agreement with the political subdivision allowing the team to play home games elsewhere, or gives the subdivision notice of the intention to cease playing home games and an opportunity for the subdivision and area residents to buy the team. Now, the Modell Law has been on the books for nearly 30 years. But until this lawsuit, it has never been enforced, never even tried to be enforced against an owner with no intention of breaking a team's stadium lease and no intention of moving a team out of Ohio. The Modell Law is not a trap for owners who are nothing like Art Modell. And the Haslam family, the Browns' current owners, are nothing like Art Modell. For the Haslams, the Browns are a family business. Jimmy is the chairman, his wife is the CEO, their daughter Whitney and her husband are both managing partners, and they live with their 3 sons here in Cuyahoga County. The Haslam family has been committed to keeping the Browns, the Cleveland Browns, since they bought the team in 2012. In his very first press conference as the new owner, Jimmy Haslam declared there was 0 chance the family would move the team to another city. And within a year of buying the team, the Haslams started investing in it. They announced a $120 million plan to improve the existing stadium, and they paid for that upfront so that those repairs and improvements could be done right away. And they're committed not just to the Browns, but to this area, to this city, and to this metropolitan region. They funded the installation of synthetic turf fields at 16 high schools in the Cleveland area. They founded an organization to combat absenteeism among school children all across Ohio. They've given more than $50 million to Cleveland's healthcare institutions, among them the Cleveland Clinic. And what's more, the Haslams were instrumental in keeping another professional sports team from leaving Ohio. In 2017, the Columbus Crew, a major league sports team, threatened to leave for Texas when it still had 5 years left on its stadium lease with the state of Ohio. Faced with a replay of Modell's departure for Baltimore, the state invoked the Modell Law to argue that the team had to stay in Columbus or face a forced sale. The Haslams stepped in. Recognizing that the Crew belongs in Columbus, in Ohio, they reached an agreement to invest in the team and keep it there, and then contributed another $220 million towards construction of a new state-of-the-art stadium and training facility for the team, which opened in 2021. And as in Cleveland, the Haslams have donated millions of dollars to support local education, parks, and healthcare in the Columbus area. As all of this should make clear, the Haslams are committed not just to Cleveland and the northeastern region, but to the state of Ohio. Now, under its terms, as I mentioned earlier, the Browns' current stadium lease ends on February 1st, 2029. By that time, the Lakefront Stadium will be 30 years old. As both the Browns and the city have long recognized, it cannot continue to serve as an adequate, let alone a first-rate home for the Browns without a major renovation and surrounding infrastructure improvements. And the city has long hoped for a comprehensive redevelopment of the lakefront, one that will connect it to downtown. So in 2017, knowing that the Browns would need to begin planning for a home that would serve the team in 2029 and beyond, Mayor Jackson asked the Browns to present a vision to redevelop the lakefront and link it to downtown. The Browns unveiled that development plan in May of 2021. It envisioned converting the shoreway into a boulevard, building a landscape land bridge, and connecting downtown to the lakefront in a way that the city had always hoped. That fall, in November 2021, the Browns met with newly elected Mayor Bibb to discuss his vision for the lakefront. And they were encouraged by his support for that plan and for a vision of a redeveloped lakefront. So the Browns began a comprehensive investigation of a renovation of the lakefront stadium for use after the lease ended in 2029. What would it take? The Browns enlisted a team of experts, developers, architects, designers, construction companies, engineers, consultants, to create detailed renovation plans and cost estimates. And in early 2023, they presented that plan to the city and the county. As the plan showed, renovating the stadium to extend its useful life by another 20 years would require at least $1 billion in upfront funding. And that renovation plan itself depended on substantial infrastructure improvements that would drive development and in turn help pay for the renovation. Those infrastructure improvements would themselves cost hundreds of millions of dollars more. Now, after the Browns delivered that detailed renovation plan, the city did not identify a clear path for obtaining the necessary public funding to complete the project by 2029. And as the months passed, it became clear to the Browns that it was imperative, it was the responsible thing to do to develop a plan for a new home that did not depend on significant city funding. So the Browns began to look at sites in the Cleveland area that could support a stadium with a dome. Not an open-air stadium, but a domed stadium. Now, stadium renovation and construction is massively expensive, at least $1 billion, easily multiple billions of dollars. And that expense is especially difficult to justify and finance for open-air NFL stadiums, because NFL teams play only 8 to 10 home games a year. But when a stadium has a dome, it becomes an all-weather, all-season facility. One that can be used not just for NFL games, but year-round for concerts, shows, other sporting events. That economic activity, that year-round economic activity, makes private financing easier to get, and it boosts the tax revenues associated with the project. Put simply, the economics of a dome stadium mean a team can build a world-class facility with significantly less burden on the public fisc. Now, after a careful search, the Browns determined that the best place for a dome stadium in the Cleveland area was a vacant site in Brook Park, less than a mile from the city line, near Hopkins Airport and their training facility. And in April 2024, the Browns presented the county with a detailed proposal for a stadium there. A dome stadium with a useful life of at least 50 years could be built in 3.5 years at a cost of $2.4 billion. Now, in recent years, new FL stadiums have been built with majority public funding. But under the Haslam's proposal, private investment will cover more than half the cost, plus any cost overruns. And the public funding would ultimately be covered by taxes and fees on revenues generated by the new development and taxes on visitors. And to be clear, that initial public funding would not come from the city, but from the state. So the new stadium will allow Cleveland and its residents access to a state-of-the-art dome stadium sitting on its southwest border at zero cost to the city. Now, one would have thought that a proposal like that, a proposal for a new stadium less than a mile from the city, requiring no city funding, would at least merit a close look by the city. Instead, the city responded in May 2024 with an emergency ordinance, directing its lawyers to enforce the Modell law to keep the Browns within city limits. And it said it was doing that to protect the interests of the taxpayers of the city. But the city did not explain how the Browns could possibly violate the Modell law by simply looking for a new stadium in the Cleveland area to play in after their lease expires. And the city did not explain how it serves taxpayers to oppose a new stadium less than a mile from the city when it will cost its taxpayers nothing. The city's position that the Cleveland Browns are not the Cleveland Browns unless their stadium is within city limits doesn't make much sense. No one thinks that a sports team leaves its city by playing in a stadium in the metro area rather than within city limits. The NFL rules make clear that a team's home territory includes a 75-mile radius beyond the franchise city. Brook Park is less than a mile from the Cleveland city line. By playing in Brook Park, the Browns would be just one of many NFL teams that play in a suburb of their franchise city. The Dallas Cowboys play in Arlington. The Los Angeles Rams play in Inglewood. Heck, the New York Giants don't even play in New York. They play across the state line in New Jersey. But no one is confused about which cities the Cowboys, the Rams, or the Giants call home. Although the city opposed a stadium at Brook Park, it still offered no clear plan or commitment for satisfying the public contribution to the cost of renovating the current stadium. In September 2024, months after threatening to sue under the Modell Law, the city asked the Browns to explore the feasibility of a domed stadium at Burke Airport. That exercise offered little hope for an alternative to Brook Park because the city does not have the authority to replace Burke Airport with a stadium. Building a stadium there would require federal legislation and regulatory approvals, legislation and approvals that haven't even been sought. But the Browns, in a sign of good faith and in an effort to reach a consensus on the best alternative to the current stadium, spent hundreds of thousands of dollars on engineers and consultants to test the feasibility of a domed stadium at Burke Airport. The final assessment, replacing Burke Airport with a domed stadium would be not only impossible under current law, but astronomically expensive even if the law changes. Because of engineering challenges at the site, building a domed stadium at Burke Airport would cost $3.3 billion, nearly $1 billion more than building one at Brook Park. And that estimate assumes construction begins right away. And of course it can't, because as we said, the approvals aren't in place and they may never be. With each year of delay, that construction cost estimate goes up. And it doesn't even cover the full cost of the airport, which would also require infrastructure improvements. So by the fall of 2024, the Haslams and the Browns had spent nearly 7 years evaluating the options for the Browns' best home, not just in 2029, but for the long term. And the answer that emerged after that exhaustive work was clear. It was Brook Park. And so the Haslams announced that they were going to focus on pursuing a new stadium at Brook Park. Now, just days after the Haslams' announcement, the city announced that it would move forward with enforcing the Modell Law against them and the Browns. Those are the threats that prompted the Browns to seek to protect their rights to find the best new home for the team, and to do so by suing in federal court. Now, the Browns initiated that lawsuit, let's just be clear, in October of 2024. And the Browns alleged that the threatened enforcement of the Modell Law violates the U.S. Constitution, in addition to being contrary to the Modell Law's text and purpose. The Brown suit asserts multiple federal claims and 3 theories of constitutional violation. First, the city's attempted enforcement of the Modell Law violates the contract clause by impairing the obligations of the lease agreement and the related agreements of the 1996 settlement, none of which require the Browns to play at the current stadium after the lease ends. Second, the Modell Law violates the Commerce Clause by impermissibly discriminating between in-state and out-of-state economic interests. The law accords preferential treatment to Ohio subdivisions and residents in the purchase of professional sports teams. And by interfering with the economic relationships between and among NFL franchises and their owners, the law places excessive burdens on interstate commerce. Third, the Modell Law violates the Due Process Clause because it is so vague in its application and requirements as to encourage arbitrary and erratic enforcement. Since the Browns brought their federal suit in October, the city has over and over again sought to delay resolution of their federal claims. After obtaining an extension of time to respond to the Browns' federal complaint, the city then filed this copycat lawsuit nearly 90 days after the Browns filed their suit in federal court. And when the Browns sought to amend their federal complaint to add related federal claims, before the city had even answered or an initial case conference had even occurred, the city opposed that amendment, even though the federal rules direct that leave to amend should be freely granted. And decision after decision, both in the Northern District of Ohio and from the Sixth Circuit, makes clear that leave to amend should be granted as a matter of course when a case is in its early stages. Then the city invoked its opposition to leave to amend to refuse to meet and confer on case scheduling and discovery matters with the Browns. The city's tactics have needlessly dragged out the federal case. But Judge Ruiz has made clear that the federal case is proceeding. He granted the Browns leave to amend their complaint in a reasoned opinion. The city, in yet another delay tactic, moved for reconsideration of that order or interlocutory appeal to the Sixth Circuit. That motion is as meritless as it sounds. The city couldn't manage to cite a single case in which leave to amend a complaint was subject to either reconsideration or interlocutory appeal. But more importantly, Judge Ruiz is not allowing that motion or the pendency of the city's renewed motion to dismiss to further delay proceedings. After the city filed these motions, he scheduled a case management conference for July, at which he will set a case schedule and initiate the discovery phase of the case. And he ordered the city to promptly file its answer to the Browns complaint. That will be on file by June 30th, Your Honor. At this point, the question is thus not whether there will be active litigation in the federal court. There will be. The question is whether there will be active litigation in this court as well. Thank you, Your Honor. With that, I'll return to my
Mr. Wilson?
Good morning, Your Honor. Just for the benefit, pardon me, for the benefit of the court reporter, my name is Bradley Wilson from the Wachtell-Lipton firm. And as my colleague, Mr. Savitt, previewed a few moments ago, I will be addressing the reasons why the court should grant our motion to stay or dismiss this action in favor of the federal action. A decision that would allow the Browns' very important federal constitutional arguments to go forward in the federal action in front of Judge Ruiz, right down the street here in the city of Cleveland. Our motion seeks two alternative forms of relief. First, the entry of an order staying this copycat action pending resolution of the federal case. Or second, dismissing this case that the city has brought as unripe and therefore non-justiciable. The court has the clear power to grant either branch of our motion. And as I said, either outcome will avoid the inevitable circumstance in which identical cases are proceeding in two places at the same time, bringing along with it a number of ills that Ohio courts have repeatedly said courts should take into account in circumstances just like these. And I'll get to those in a moment. I'll start, as our papers do, with the Browns' motion to stay. There can be no dispute that this court has the power to stay this case in favor of the federal action. As the Ohio Supreme Court recognized in the Hochhausler case, this power to stay cases is inherent within a court's jurisdiction and essential to the orderly and efficient administration of justice. When a party asks for a stay of proceedings, as the Browns have done here, the court is instructed to focus on a number of considerations. In this circumstance, the most important considerations are comity, orderly procedure, and judicial economy. This has been settled Ohio law for more than 50 years, following the Supreme Court's decision in the Zellner case, which is referenced on the slide and cited at some length in our papers. In the Efros case, also cited in our papers, the Court of Appeals distilled these considerations down in a way that I believe captures what is the essence of the question that Your Honor has to answer. And that is whether a stay of proceedings is necessary to avoid a collision course. And a collision course is exactly what we're facing if the city is allowed to proceed with this copycat lawsuit. Comparing this case with the federal action, first of all, we have substantially overlapping parties. In both cases, the Browns and the Haslams on one side and the city on the other are the critical parties. We also have identical issues of law and fact. Resolving both cases will require the resolution of the Browns' important federal claims challenging the Modell Law and its application to the Browns under the U.S. Constitution. And that will in turn require factual findings about the purpose and effect of the Modell Law. Those are unavoidable questions in both cases, Your Honor, as I'll explain in a moment. Now, counsel for the city said this morning that this case is really just a lease dispute. We don't think that's right, Your Honor. We think that's obviously not right. From the beginning, this dispute has always been about the Modell Law and the U.S. Constitution, and nothing the counsel said this morning changes that. It is true that the city has a tack-on claim, it's count 2 of their complaint, for anticipatory breach of the stadium lease. But if the court looks at the complaint, and specifically at paragraph 82, the court will see that a necessary predicate for that anticipatory breach claim is a violation of the Modell Law. Without it, there is no breach and can be no breach, as the court will see, and as I think the city would concede if asked. We'll talk a little bit more about the anticipatory breach claim in a moment, but we just don't fundamentally disagree with the concept that this is a lease case. There's a lot more significant matters at stake, and they're constitutional in nature. Proceeding with two...
It is an issue, correct?
Pardon me?
It is an issue, the lease.
Your Honor, I don't think that the lease is an issue. I think that claim will be dismissed or should be dismissed. As I said, the provision that they're relying on is a compliance with law provision. We're not even sure that it really applies in the way that they're trying to apply it, but even if it does, and I'll accept that it does for purposes of this pleadings motion, the theory is that the Browns are violating the Modell Law today. We don't think that's right. We laid that out in our papers, and I'll talk about it in a moment. And if the Browns aren't violating the Modell Law today and can't violate it until the lease term ends at the end of the 2028 season, which we think is clearly correct under the statute, the compliance with law provision isn't even implicated, because that provision, as the court would expect, like every other provision in the lease, goes away when the lease expires. It explicitly says that the Browns have to comply with the law during the term of the lease, and the Browns have done that. There's no allegation that they've breached the lease in any other way, and they will continue to do that through the end of the lease term. And I don't think the city is disputing that, and certainly they don't allege that the Browns have expressed any intention to leave Huntington Bank Field before the lease ends. So we don't think that the lease is properly in the case. We think it should be dismissed whether or not this case goes forward. And I'm happy to turn to that now, or I can come to it when we get to the motion to dismiss. As I said, allowing the two cases to proceed in parallel in two courts is not only inefficient and needlessly expensive, it sets up a direct clash between this court and Judge Ruiz. It incentivizes a race to judgment that deserves the interests of justice, this court, the federal court, and all of the parties involved. Now, why would we expect a race to judgment in the two courts? The reason is that the federal and state actions are, for all intents and purposes, identical. In both cases, the court will be called upon to decide whether the city has the legal right to invoke the Modell Law and prevent the Browns from moving to Brook Park in 2029. Given the significant overlap in parties and issues, the decision in the court that reaches judgment first could potentially be res judicata in the other. We certainly would expect the prevailing party to make that argument. Making matters worse, at every turn along the way to that final judgment, there will be a constant risk of inconsistent judicial rulings on scheduling matters, discovery matters, and subsidiary issues of law and fact that may come up along the way during the case. And that'll require the parties to be shouldering different obligations and different case structures at the same time on the same issues in two different places at courthouses located just a few miles apart. Staying this case pending resolution of the earlier filed federal action avoids all of these dangers. There will be no judicial duplication, no risk of potentially divergent rulings, and no incentive to play games to get one case or the other to the finish line first. Now, Ms. Reddy talked about some of the ways that the city has been trying to play catch-up by slowing down the federal action to try to prevent it from moving forward. Judge Ruiz has not accepted that. He's moving the case forward as we've talked about. We have a conference in front of him in a couple of weeks, and the case will be moving. But if this case is moving as well, Your Honor can expect that the parties will be trying to grapple to get their case to judgment first, which we don't think is efficient or consistent with Ohio law. Now, the city caused this problem, this collision course, when it filed this copycat lawsuit 82 days after we sued in federal court.
Why are you calling it copycat?
It's the same case, Your Honor. It's the same case. It's a question of whether the Modell Law applies and whether it is constitutionally permissible for it to be applied to the Browns. That's the essential issue.
Copycat in terms of federal and the state being the same.
I'm calling it a copycat case, and I'm happy to stop calling it that. I don't mean to deride this case. It's certainly not this court. It's a copycat case because it's an unnecessary lawsuit. All of the issues that the city needs to have resolved with respect to the future of the Browns and Huntington Bank Field will be decided in the federal action. The federal action is, at its core, a declaratory judgment suit. We are seeking a judicial declaration from Judge Ruiz that the Browns have the right to move to Brook Park after the lease expires. That's true because of the federal Constitution, which would prevent the Modell Law from being applied in the way the city is trying to apply it. And it's also true just as a matter of state law itself. It's true as a matter of how the Modell Law should be interpreted, consistent with its text, history, and purpose. That's what the federal case is designed to achieve, and we brought that lawsuit as soon as we knew there was a threat to enforce the Modell Law because the Browns need prompt clarity. The Browns need to know that they are going to be able to move to Brook Park because there's a lot of work going on to try to prepare the site for football in a few years from now. And as you would expect, building a state-of-the-art dome stadium takes time. And so we need clarity from the federal court promptly so that the Browns know and don't have a dilemma where they're forced to choose between building their stadium and risking a court someday telling them they can't move there, or not building the stadium based on the threat from the city to enforce the Modell Law at the end of the lease. So that's why we sued in federal court. That's why we're pursuing prompt relief in federal court. And the city can litigate all of its issues there. And those issues will be litigated in the federal action. That case is moving forward, notwithstanding the city's earlier arguments that the federal court somehow doesn't have jurisdiction to consider federal constitutional claims. Now, this problem has come up before, and so not surprisingly, Ohio law has addressed the ways in which courts in this court's position can avoid the collision course that Ephros talks about. Ohio courts have frequently granted stays pending resolution of closely related federal court proceedings. The Barnett case cited in our papers is one example. In that case, the court gave priority of jurisdiction to an earlier filed federal case that involved identical claims under a federal statute. The court explained that a stay was appropriate to eliminate dangerous conflicts of jurisdiction and an unseemly race to judgment.
What was that case about?
Barnett, I believe Barnett, Your Honor, let me remind myself because I don't want to misspeak. Yes, that was a case involving a claim under a federal railroad statute and whether employers had violated employees' rights under that statute. It involves similarly weighty constitutional issues, as I recall, but they're federal issues, and so they should be decided in a federal court. Zellner is another example. Zellner was a desegregation case in which there were competing proceedings in federal and state court. And the Ohio Supreme Court held in that case that a first filed federal action to determine whether a decision by the Board of Education of this state violated the petitioner's constitutional rights should proceed in lieu of a state court mandamus proceeding. And that outcome, the court said, the outcome of staying the state proceeding was controlled by considerations of orderly procedure, as well as the federal court's greater familiarity and expertise with the subject matter. Now, obviously, this isn't a desegregation case, but we don't think that that's a sufficient basis to distinguish Zellner, because it is a constitutional case. There are very significant constitutional claims here. There's a Contracts Clause claim, there's a Due Process claim, and there's a Commerce Clause claim. And the reasoning of that case, that the federal courts are ultimately better equipped to deal with those kinds of federal constitutional arguments, applies with full force here. The Browns are seeking to vindicate important federal constitutional rights. And the vehicle they're using to do that is one that has been endorsed over and over again by the U.S. Supreme Court. Now, that vehicle is something that's known as a pre-enforcement declaratory judgment action. And I'll talk more about that in a second. But the Browns are entitled to have their constitutional arguments decided by a federal court. In fact, the Browns not only had the right to present their constitutional arguments to the federal court, but that was the most appropriate forum for them to do so. As the U.S. Supreme Court held in the Steffel case, federal courts are the primary and powerful reliances for vindicating every right
given by the Constitution, the laws, and the treaties of the United States. Now, as I said before, the city did question at one time in their papers in this case whether the federal court had jurisdiction over the Browns' claims. The city submitted no argument to the court on that issue. They didn't cite a case. They just said that there was no jurisdiction in the federal court. Now, that argument was wrong. It was always wrong, and the city has now abandoned it entirely. When the city filed its most recent round of motion to dismiss papers in the federal court on June 9th, the city dropped its jurisdictional challenge. That's a huge concession, although it's one the city had to make. It's an acknowledgement that the Browns' federal constitutional claims are properly presented to Judge Ruiz for adjudication. As I alluded to a moment ago, the Browns' federal court action is a pre-enforcement challenge. Pre-enforcement challenges allow parties who are threatened with the unconstitutional enforcement of a state law to seek relief from the federal court before taking the allegedly unlawful action. There are a number of Supreme Court cases I could cite to this court on this proposition, but I've chosen two. The Woolley case from 1977, which said that when a genuine threat of prosecution exists, a litigant is entitled to resort to a federal forum to seek redress for an alleged deprivation of federal rights. And then the Metamucil case, which was a patent case. Where threatened action by government is concerned, we do not require a plaintiff to expose himself to liability for bringing suit to challenge the basis for the threat. For example, the constitutionality of a law threatened to be enforced. And that's exactly what the Browns have done here. They believe that the city's threat to enforce the Modell Law at the conclusion of the lease is unconstitutional. They needed clarity on that question, and they brought prompt action in the federal court to seek clarification of their legal rights, just as the Supreme Court has told them they should. Now, this right to pursue a federal remedy in the pre-enforcement context is deeply embedded in the law. And as I said, the city's threat to enforce the Modell Law shows why this right is so important. As the Browns allege in their federal complaint, absent prompt relief, the uncertainty created by the city's attempt to enforce the Modell Law against the Browns will unlawfully impair their ability to exercise their contractual and legal rights to call a new stadium home in 2029. Without the federal action, the Browns would be forced to decide whether to risk the possibility that billions of dollars in private and public investment in the Brook Park project could be wasted, or abandon the stadium project entirely and bow to the city's threat. The law does not require the Browns to make that very difficult choice. By filing this state court action and then opposing the Browns' motion to dismiss or stay it, the city is trying to deprive the Browns of their right to have the federal court resolve their federal claims. This outcome is contrary to settled law. As the U.S. Supreme Court held in the England case, there are fundamental objections to any conclusion that a litigant who has properly invoked the jurisdiction of a federal district court to consider federal constitutional claims can be compelled without his consent and through no fault of his own to accept instead a state court's determination of those claims. But that's exactly what the city is attempting to do here, to force the Browns to bring their constitutional challenges in this court. Now, the city argues that the Browns could simply reserve their federal constitutional arguments, present only state law arguments to this court, and then ask Judge Ruiz at some point in the future to resolve their federal constitutional claims. That would, for one thing, be very, very inefficient because we'd have two full track legal proceedings going back to back in circumstances where, as I said, the Browns really do need urgent relief and a speedy resolution of this dispute. But there's a bigger problem, which is that what the city is saying doesn't work as a matter of res judicata. Contrary to what the city tried to tell this court in its papers, the Browns can't reserve their constitutional arguments and leave them out of this case. The city is alleging that the Browns have already violated the Modell Law. The city is alleging that they are already entitled to injunctive relief, including relief that would order the Browns to sell the team, and damages. We don't think their interpretation of the Modell Law is correct. We think those claims are unright. But let's accept, for the sake of discussion, that the city is right and that there is, in their view, a current violation of the Modell Law. If the city prevails on that claim and gets a judgment in its favor, that'll very likely be res judicata as to the federal action. The Browns would be then precluded from making any further argument to try to avoid liability under the Modell Law. They'd be stuck with the judgment of this court, and their federal constitutional claims would have gone by the wayside. So unless the court grants this motion, the Browns will have no choice. They'll be forced to bring their constitutional claims and arguments and defenses in this proceeding as well. That's not how it's supposed to work, Your Honor. Again, the England case, the right of a party to choose a federal court where there is a choice cannot properly be denied. And we think that's the principle that guides the resolution of this motion at its most fundamental level. Now, on the other hand, staying this case and allowing the state law issues to be decided in the federal action, if they need to be reached at all, prejudices no one's rights. Because there is no question that Judge Ruiz has jurisdiction over the state law claims as well under the district court's supplemental jurisdiction. In fact, the state law issue was already presented for adjudication in the federal action. The Browns raised it in their complaint as an alternative ground for resisting the Modell Law's application. And Judge Ruiz is perfectly capable of addressing that issue should he decide that he needs to reach it. Now, the city says that this court needs to adjudicate the Modell Law issue because it's a state law issue, and it, of course, is that. But this isn't the kind of state law that this court, or really any other in the state of Ohio, has any experience interpreting or applying. As Ms. Reddy pointed out, it's only been invoked once in completely different circumstances by a different court in Franklin County. And that case resolved before it really got off the ground. The only written decision that's available on the Modell Law is a motion to dismiss decision several years ago in another county. So neither the state nor the federal court.
But the case was, the motion to dismiss was denied.
The motion to dismiss was denied. Very different circumstances there.
What was the difference?
Well, for one thing, factually, the team there was breaking its lease and was trying to leave before the lease was over, which is a fundamental difference, much more like the Art Modell circumstances. And then from the perspective of the Contracts Clause claim, which is our first of three arguments, that wasn't presented in that case because there the Modell Law existed when the owner of the team signed the lease. And so the owner signed the lease with knowledge of the Modell Law. Here, the lease was signed before the Modell Law went into effect, and essentially the city is trying to graft a new term onto the lease, a material term, after the NFL, on behalf of the new owner of the Browns, signed the lease. And so totally...
Was that the reason that they have denied the...
Well, the argument wasn't even presented, as I recall, Your Honor, because it wouldn't have been implicated in that case. The factual predicate for the Contracts Clause claim was not presented there. And I would also say a motion to dismiss is obviously a very favorable pleading standard for the city, well, or the, I don't remember, I believe it was the state in that case, Your Honor, but for the municipality or the government entity, it's a very favorable pleading standard, and I don't think that the judge in that case at all reached the ultimate merits of the case. But in any case, yes, there is one decision from Franklin County, and Your Honor can read it and try to apply it for whatever persuasive value it has, but the same is true of Judge Ruiz. It's not as though you personally, or frankly any court here in Cuyahoga County, has ever considered those issues. There's no binding authority from an intermediate appellate court or the Ohio Supreme Court. We're essentially writing on a blank slate, although admittedly there is the one precedent. Now, as I said, we're skeptical that Judge Ruiz will need any help addressing the state law issues in the case, but if he were to decide that some interpretive guidance would be helpful to him, there's a ready-made procedure for that to happen. Federal courts can certify questions of state law to the Ohio Supreme Court for a definitive answer. This procedure is established by Rule 9.01 of the Supreme Court's Rules of Practice. It's been repeatedly endorsed by the Ohio Supreme Court. cases like Scott v. Bank One Trust. And it's, as I said, an available option to Judge Ruiz if you want some help with any specific issues under the state law interpretation of the Modell Law. So by granting a stay, this court would ensure that the Browns' federal constitutional claims are decided where they should be, in the federal court, but also leaving open the possibility that this state's highest court could issue definitive guidance on the meaning of the Modell Law, which is ultimately what is needed to ensure clarity going forward for teams that find themselves in the Browns' position. Now, I'll just briefly address a point that I touched on earlier, and I think Your Honor asked about this. The city has argued that a resolution of the federal case will not resolve the dispute, but that's just not correct, Your Honor. In the federal action, as I said, the Browns are seeking a declaratory judgment that the city cannot enforce the Modell Law against them. And a judgment on that claim will most likely bind the city and the Browns under res judicata principles. That is indeed the whole point of declaratory judgments, as the court, of course, knows, to establish a binding adjudication that enables the parties to enjoy the benefits of reliance and repose secured by res judicata. That's from the Holland case in the U.S. Supreme Court just 2 years ago. Let me turn briefly, Your Honor, if I could, to the motion to dismiss arguments, although I've already previewed several of them in my remarks. Unless Your Honor has any further questions about the stay motion. Thank you. As we said in our papers, if the court does not stay this case in favor of the federal case, it should dismiss the case entirely. The grounds for dismissal are straightforward. First, counts 1 and 2 of the complaint are not ripe. Both claims are premised on an alleged current violation of the Modell Law in circumstances where it is not possible for the Browns to violate the Modell Law for at least several years.
For at least what?
For at least several years, if and when the Browns leave Huntington Bank Field and start playing their games somewhere else. As to count 3, the declaratory judgment claim, it should be dismissed because the city does not plead an essential element of declaratory judgment claims under Ohio law, and that is a need for speedy relief to prevent hardship on the party seeking declaratory relief. I'll start briefly with counts 1 and 2. These are the claims, as I said earlier, Your Honor, that are dependent on an allegation that the Browns are currently in violation of the Modell Law. Count 1 is explicitly a claim for breach of the violation of the Modell Law, and count 2 is the anticipatory breach of the lease claim. As the Ohio Supreme Court explained in the Quinn case, to be justiciable, a claim must be ripe for review, and a claim is not ripe if it rests on contingent events that may never occur at all. Counts 1 and 2 of the city's complaint, Your Honor, are not ripe under this standard because they are contingent on a future event. And that future event is the Browns ceasing to play home games at Huntington Bank Field by the lakefront, just out back, and beginning to play most of their home games elsewhere. That is the triggering event for a violation of the statute. And we know that because that's what the statute says. Now, we don't think the Modell Law applies here for a whole bunch of reasons. But as Mr. Savitt said, those merits issues are for another day. And we think for a different forum. But in any event, they're not for today. What matters for today's purposes is this. Even when the Modell Law applies, it merely forbids an owner of a professional sports team that uses a tax-supported facility to cease playing most of its home games at the facility and begin playing most of its home games elsewhere. That prohibition is found in the first paragraph of the Modell Law, which is on the screen at the moment, and it's the only prohibition that the law contains. The Modell Law does not prohibit thinking about moving. It doesn't prohibit intending to move. It doesn't prohibit preparing to move. Unless and until the team moves, it can't violate the Modell Law. That's what the text says. Now, the rest of the statute creates exceptions or safe harbors that permit the team to play elsewhere when certain conditions are met. Those conditions are described in subsections A and B of the Modell Law. And this is the only plausible interpretation of the Modell Law's text and structure. As the city, I think, very nicely summed up the issue in its brief at page 3, the law tells owners of Ohio sports teams they cannot move unless they follow certain conditions. Exactly. They can't move unless they follow the conditions. The Browns have not violated the Modell Law's prohibition. There is no well-pleaded allegation that the and there's no well-pleaded allegation that the Browns will violate the Modell Law's prohibition for at least several years into the future. There's no allegation that the Browns have ceased playing at Huntington Bank Field, and there's certainly no allegation that they've started playing their games elsewhere. The city instead alleges that the Browns have manifested their intentions to stop playing at the current stadium at some point down the road. That's not a violation of the statute, as its text makes clear. That's also not how statutes work. I can't think of a single example of a statute in this state or any other jurisdiction that prohibits the formation of an intention to do something. Now, it may be that the Browns are taking a risk by intending or planning to move to Brook Park, but that's precisely why the Browns are seeking declaratory relief in the federal court, to clarify that question now that the city has threatened to invoke this law against them at some point in the future. In all events, though, the Browns' present intention to move to Brook Park remains subject to numerous contingencies, one of which is the impending June 30th deadline for the finalization of the state budget, which it is hoped will include a substantial amount of public financing for the new stadium. And there are a number of other contingencies that will need to be addressed in the future before the Browns actually move to Brook Park. But the key event, Your Honor, or the key point, Your Honor, is that the Browns are not moving, they're not alleged to be moving for several years, and therefore there can be no current violation of the Modell Law. Now, we heard from counsel's remarks this morning a harder form version, I would say, of this argument, Your Honor, that was alluded to in their briefs. That the city tries to salvage its current violation theory by pointing to count 2 of their complaint, the anticipatory breach claim, and the general compliance with laws provision in that lease, which is, I'm sure the court will agree, a fairly common provision in lease agreements. That attempt fails, Your Honor, as I briefly summarized earlier. The Browns have made it clear that they intend to remain at the current stadium through the end of the 30-year lease term and to comply with all of the lease's provisions in the meantime. The city does not plead a single fact to suggest otherwise. Ultimately, the flaw with this anticipatory breach argument is the same flaw that dooms count 1 of the complaint. All else aside, even if this provision means what the city says it means, the Browns can't violate the Modell Law until they move to a new stadium. And that won't happen until the lease expires. By that time, as you can see from the highlighted text, this provision that they are invoking will no longer apply to the Browns because it terminates when the lease terminates at the end of the 2028 season. I'll very briefly conclude, Your Honor, by addressing count 3, the city's parallel, or maybe better phrase would be mirror image, declaratory judgment claim. On the surface, this claim does look like a carbon copy of the Browns' declaratory judgment claim, but the parties are at very different positions, and that matters under the law. As the Court of Appeals held in the T&M Machines case, an essential element for declaratory relief is that speedy relief be necessary to preserve the rights of the parties. The court went on to explain that unless delayed review will cause hardship, an issue is not ripe for declaratory judgment. The city pleads no facts establishing that it needs speedy relief to prevent hardship on itself. In its brief, the city cited an allegation that a Brook Park stadium would draw events-related investment and tax revenue away from Cleveland. But that danger is contingent on future events that will not occur until 2029, if they occur at all. The city's complaint is very clear on this point and this timing. The complaint alleges in paragraph 42 that the city will lose economic output every year should the Browns abandon their stadium. The Browns, by contrast, face a massive dilemma right now. The Browns want to proceed with the Brook Park opportunity. They want to invest additional time and capital into that project. But the city's threat to invoke the Modell law against them is complicating those efforts and putting that investment at risk. That is why the Browns need relief from the federal court. The city is perfectly well situated as things stand. The uncertainty benefits the city. As the Ohio Supreme Court explained in the Burger Brewing case, and this pertains to the Browns, not the city, it was to lift people from the horns of such a dilemma that the Declaratory Judgment Act was enacted. The Browns case cries out for speedy relief. The city's does not, and count 3 should likewise be dismissed. Your Honor, unless you have any further questions, I'd be happy to cede the podium to Mr. Herdman and reserve the balance of our time for rebuttal.
Thank you.
Thank you, Your Honor.
Judge, would you mind if I took a break? Sure. Thank you. Just, for just about 5 minutes.
Sure.
Thank you.
Let's recess for 5 minutes.
That one's you. That's still full.
Thank you. All right, like 2 minutes, 2 minutes. Okay, we all set? So would everyone please rise? Court is now back in session. You can be seated.
Mr. Herdman, you may proceed.
Thank you, Judge. Appreciate it. Good morning again.
Good morning.
All right, well, appreciate, again, the opportunity to address the court. So I'll kind of pick up where I left off at the beginning of the morning, Your Honor. Just point out, I think, what you've heard is what I think is a fairly transparent effort by the Browns to deprive the city of an opportunity to have its claims heard here. The city is the natural plaintiff in this case. The city is the party that is aggrieved by the violation of the Modell Law. The city is the party, the landlord, that is aggrieved by the breach of the lease. The city is the party that is the natural party seeking relief, declaratory relief. And the Browns, by rushing into federal court in October of last year, sought to deprive the city of seeking relief on those claims in its natural setting here on state law claims in state court. That's what you heard this morning. All of that effort to explain why they're in federal court and explain why this is not the appropriate setting for state law claims, that's all an effort to keep this case away from Judge Lawrence Seymour. And I would just say, it's clear to us that these state law claims belong here, but taking our word for it, I realize that only gets us so far in an argument like this. How about what the state of Ohio has to say about it, though? Because what you heard this morning was what the Browns' position is on this, but they didn't mention what the state of Ohio has had to say in that exact same federal litigation. Because the state of Ohio is an intervener in that case, Judge. The Attorney General for the state of Ohio, Dave Yost, has filed over and over and over again in that federal court case in support of the city's position that the Browns case has no business being in federal court. And just to take one quote out of one filing, this is from a filing by the Attorney General of the state of Ohio, David Yost. Abstention and constitutional avoidance principles dictate that the threshold state law questions that the Browns present be answered first by an Ohio court, end quote. That is just one quote. That is from their motion to dismiss the Browns' second amended complaint at page 2. There are many, many, many more from which I could have chosen. I selected one and only one, but that is the position of the state of Ohio as to which court should be hearing these claims. The move to stay should be denied. That is apparent and obvious. First of all, this is a purely discretionary decision for this court. There's nothing mandatory about this. A stay would only be proper if the federal court properly had jurisdiction and if that federal court possessed a greater familiarity and expertise with the action's core issues, and if that federal court could provide a more complete disposition of the issues. None of that holds true here. Now, on the jurisdictional issue, I don't know what papers the Browns have been reading at federal court. We have not abandoned our challenge of the jurisdictional issue in federal court. We have filed a motion for reconsideration on Judge Ruiz's grant of their motion for leave to amend their first amended complaint, stating that the court did not have jurisdiction to grant that motion. It is a jurisdictional issue. I would also point out that the reason that they have filed their most recent complaint on Memorial Day, weeks ago, is because their second complaint, that is their first amended complaint, I think they would have to admit, did not have federal jurisdiction. They had to file and seek leave to file an amended complaint because their second complaint that they filed, again, they filed 3 complaints. So this idea that we've delayed that case is preposterous. They filed their first complaint in October, which was apparently such a rush job that they had to file an amended complaint weeks later. Then we fully briefed a motion to dismiss on that first amended complaint, which prompted them to seek a motion for leave to amend that complaint because it was so lacking in federal jurisdiction that the only way that this case could survive in federal court was for them to file this complaint that they just got permission to file on Memorial Day. So this idea that we have delayed that case is absolutely off base. And this idea that it is some like neat and tightly packaged bundle that's teed up for Judge Ruiz to decide right away is just not true. This case has proceeded. This is the second time we've appeared before Your Honor. It's true that we are in the process of scheduling a date to appear in front of Judge Ruiz for a case management conference to set a discovery schedule, but we're already in discovery in front of Your Honor. We've already served discovery, 2 sets of discovery on the Browns. We're not happy with the responses that we've gotten back on the second set of discovery. We'll deal with that, and we're dealing with the Browns on their responses. But we're in discovery in this case. We're not in discovery in the other case. And we still have yet to fully brief the motion to dismiss on their newer complaint. So I'm not the Browns, obviously, we're the city, but this idea that they're going to get some quick resolution in the federal case, I think this case is moving along at a nice pace here in state court. And if you wanted certainty on the issues that they claim are so important to being able to get the Brook Park development built, this one seems to be moving at a more brisk pace and more certain to result in some sort of relief to both parties. So they seem to think that they're going to get it in federal court faster. They might. I don't know. I can't predict that. But all I'm saying is based on what has happened in this court in this case so far, it seems to be moving in the right direction and moving along. And like I said, we're already in discovery in this case, and we've talked about a discovery schedule with Your Honor. So that's in terms of the standard, the jurisdictional one. I would just say, that is to be decided even as a threshold matter in federal court. I don't think that it's as clear and settled as the Browns would paint it. On which court possesses greater familiarity with the action's core issues, I don't think that's even a close call. The Browns reference the pre-court case, the other state court action that dealt with the Modell law. Judge, there's a reason why there's only been one other case that has dealt with the Modell law. Every other professional sports team in Ohio has wanted to comply with the law. We've only had 2 teams that have tried to violate it in the entire history of the law in 30 years. The Columbus Crew and now the Browns. So it's not a surprise that you've only got one other precedential case out there. Why should we be surprised that there's only one other case out there on a motion to dismiss? And it was an Ohio state court that interpreted the Modell law in that case, not a federal court, an Ohio state court. And when the Browns speak of interpreting the Modell law, or whether their theory of the Modell law is triggered, I'll get to that in a moment, or when it's triggered, they are talking about an Ohio law passed by an Ohio legislature, signed by an Ohio governor, and previously interpreted by only one court, which is an Ohio court. Why would we not have that interpreted by an Ohio court, by an Ohio judge, Judge Lauren Moore? Just to pick up a thread I mentioned earlier, we made the same abstention argument in federal court, and that's exactly what the Attorney General said and agreed with us on, that quote that I read earlier. And it makes sense because those state law questions will come before any federal law question. If this court determined that the Modell law did not apply to the Browns in their proposed move to Brook Park, if you agreed with their interpretation of the merits of the Modell law, those federal questions would not even be reached. It would just be a state law interpretation. There'd be no need to discuss the federal law. And on the second part of the standard, again, this court can completely dispose of the case. The federal court cannot. As I just said, if this court determines the Modell law does not apply to the Browns, the case is over. There would be no federal questions to address. If the federal court determined that the law was constitutional, the case is not over. We'd have to come back into state court. We'd have to come back before a state court judge, and then we would have to enforce the Modell law. It wouldn't be over. There's no way that the federal court can entirely dispose of the case. You can. And more importantly, there are claims, as we've already talked about, there are claims in this case which will not be touched by that federal case at all. I'll get to that right now. We have pled a standard breach of contract claim. It's predicated on the stadium lease. And that lease has provisions in it that we allege are in breach and have nothing to do with the Modell law. Just as an example, paragraphs 89 to 93 of the complaint refer to section 9B of the lease. Section 9 of the lease was referenced in that PowerPoint as well. The lease is Exhibit A to the agreement. Section 9B2 of the lease requires the lessee, and I'm going to quote here, Judge, I apologize, but this is also referenced in the complaint. Section 9B2 of the lease requires the lessee to, quote, 1, hold, maintain, and defend its rights to play professional football in the city of Cleveland, Ohio. So that provision is up in the air right now. Section 9B2, to not negotiate with any person or do or suffer to be done anything which will cause such rights to be lost or impaired or diminished in any respect or transferred, relocated, or otherwise moved. Section 3 of 9B2, not sell the franchise to another person or entity which has the then present intent to relocate, transfer, or otherwise move the franchise to any other city or location. Section 4 of 9B2, not modify the franchise to permit the Browns to play regular season home games or postseason home games other than is required by the rules of the NFL in any other such city or location, end quote. We did not quote the entirety of Section 9B2 in the complaint. That's quoted in various paragraphs 89 to 93. But that gives you an idea of the fact that it's not wholly reliant on paragraphs relating to the Browns' compliance with Ohio law. That there are other provisions in the lease that the Browns are violating currently. And they all relate to where the Browns are playing professional football. And
It specifically says any other city.
yes, it says not sell the franchise to another person or entity which has the then present intent to relocate, transfer, or otherwise move the franchise to any other city or location. That's Section 3. Section 1, which is quoted in our complaint, requires the lessee to hold, maintain, and defend its rights to play professional football in the city of Cleveland, Ohio. Not Brook Park. City of Cleveland, Ohio. Now, if they're going to say that we didn't, specifically allege that they breached that particular provision, well, apparently, liberal pleading or liberal amendment of a complaint is all the rage. So, what's good for the goose is good for the gander. If that's an argument that they're going to raise in 5 minutes when they get back up here, I'm just previewing that might be something you hear. We would anticipate that's something that they're going to say. But we have alleged that particular provision in our breach claim, Judge. And whether or not we'd have to amend it, I say that for another day. But I am pointing out to the court that we have alleged specific provisions in the lease with the Browns that we claim are in breach now. And these are not subject to what's going on in federal court. They have nothing to do with the Modell law and whether or not the Browns are violating the Modell law. These are standard lease provisions that are in breach. And that I think undermines this whole idea that this is a copycat lawsuit. I know you focused on that too. It's not, and it's not a copycat lawsuit. It's not identical. It's not nearly identical. It's a different lawsuit, grounded in different claims, grounded in a different set of disputes. Namely, let's just call it what it is. Like I said before, it's a landlord-tenant dispute. And there is a Modell law component to it, of course. We have a statute that we want to enforce. But all of that together is before the court, and appropriately so. And all of that weighs against there being a stay here, for the reasons I just outlined with respect to the standard. And so the entirety of this case belongs right here with this court, and the court can apply law to the entirety of the case and apply Ohio law to the entirety of the case and address all the issues in this case. I also just want to pause for a moment because I think that this is important, particularly with respect to what I just read with respect to 9B in the lease. Since we last appeared before this court, I think it was back in April, I think it's important to address what has happened in the ensuing weeks. And again, I'm not even sure I would have addressed this, but for counsel going through chapter and verse about all of the funding that is out there, all of the contingencies that have to happen, everything that's on the table with respect to funding in the state legislature. In the past several weeks, the General Assembly has considered various budgeting proposals with respect to the Brook Park Stadium for the Browns. They appear to be on the precipice of deciding some of those funding issues. And they, depending on what the structure of those funding decisions is, there is a funding decision that could be made within days that would direct hundreds of millions of dollars in Ohio taxpayer money to the Browns for the purpose of building a dome stadium in Brook Park, Ohio. And depending on how that funding is structured, whether it's offered directly to the Browns for the Brook Park project, that could affect city decisions on whether to seek equitable relief. And this proceeding is the most natural and immediate venue for doing so. And I raise this because this matter has been pending for 6 months. We've already started discovery. It's the second time we've appeared in front of you. And it's clear that we are moving this case. And so if certainty in litigation is so important to the Browns, and I trust that it is, I don't understand why they would want to stay this case, given all that I've just addressed. This is the natural place for us to be, for seeking relief related to all of those issues. And as I started off this morning, Your Honor, it's clear the Browns don't want to be here. It's clear that this Ohio professional football team does not want to be in Ohio court having an Ohio judge decide issues of Ohio law. That is particularly galling given the fact that they are asking the Ohio legislature for $600 million of Ohio taxpayer dollars. They are also asking the county of Cuyahoga for almost $200 million in Cuyahoga County taxpayer money to help fund this Brook Park Dome. They are asking a municipality in Cuyahoga County for $400 million to fund this Brook Park Dome. That's a municipality of less than 20,000 people. $1.2 billion they are asking of Ohio taxpayers, and they don't want an Ohio court to decide whether or not an Ohio statute or an Ohio contract applies to an Ohio professional football team. That's what they're saying to this court. And so we have, I don't know the answer to that question, why they don't want that. I think there are plenty of other important questions that we would like answers to on behalf of the city. When do the Browns intend to comply with the Modell law? I mean, that's an important question that we would like to get answered. how do they propose to comply with their lease provisions? That's another important question that we'd like answered. Those questions are not going to be answered in federal court. They can only be answered here, and they can only be answered once we start moving forward on this case after you deny their motion for a stay. And that's, again, what I'm asking you to do here today. With respect to the dismissal, I'll just start with a simple premise. I think they tell you everything you need to know about the merits of their dismissal by posing it in the alternative. I don't think I've ever seen that before, where somebody's asked for stay and then a dismissal in the alternative. It's clear that they have done this sort of in passing, but I'll address it. Let me just get to the heart of this. They are saying, when you listen to Mr. Wilson's presentation on their position with respect to the Modell law, this is literally what they are saying. We would not be in a position to enforce the Modell law on behalf of the city of Cleveland until somebody kicked a football in Brook Park at the opening of the first Browns game to be played at the Brook Park Dome. That is what he said. That until that happens, they haven't started playing a home game away from Huntington Bank Field. Now, again, I think that gets to the merits of the case, but that is how preposterous this position is. The only thing the court has to consider right now is whether or not we've pled that they're violating the Modell law, and we obviously have. He leaves off that we pled that the Browns gave notice that they're leaving the city of Cleveland and they're going to stop playing their games at Huntington Bank Field. We pled that. We pled that at paragraph 66 to 67. And we pled that they haven't given an opportunity for anyone else to purchase the team at paragraph 68 to 69. That's the standard for motion to dismiss. Did we plead a violation of that law? Of course we did. But that's, if you string out what he's saying, it flies in the face of everything else that they presented. Everything else, that the Browns have exercised an option on 176 acres in Brook Park, that they have all of these designs and schematics on the Brook Park Stadium. Of course they're going to move to Brook Park. That's their whole plan. That's what they want to do. That's why they're going down to Columbus and talking to the legislature and trying to secure all of this funding. That's the notice. The notice that they're moving to Brook Park, we've alleged in the complaint. But are they really trying to tell the world that they're not moving to Brook Park? Because that's what Mr. Wilson said. He said, we have a present intent to move to Brook Park, but until we actually kick the football in our first game in Brook Park, the Dome Stadium at Brook Park, you can't enforce the Modell law against us. That is what he said. I cannot believe that that's what the Ohio legislature intended. I cannot believe that that's the way that the law was ever intended to work. And by the way, for purposes of surviving a motion to dismiss, we don't need to show that. We have pled the complaint the proper way by showing that they gave notice that they want to play somewhere else, and by showing that they have not given anyone else an opportunity to purchase the team. So we survived the motion to dismiss on ripeness grounds. Same thing with the breach of contract claim, given the fact that they are presently violating the Modell law. Can I have just a moment, Your Honor? I just want to make sure I've addressed it.
Yes,
Okay, thank you very much. I'll
thank you so much.
turn it back over.
Very sad.
Oh, thanks.
Your Honor, good morning. William Savitt again. A few remarks in rebuttal, if I might. Thank you. Shortly before closing, my friend Mr. Herdman told you how different this case and the federal case were, that there were important points of distinction that rendered them completely separate. 10 days ago, he signed a brief and filed it with Judge Ruiz. And here's what he said about the two cases. When state and federal cases are parallel, as they are here, and went on.
I'm sorry, I didn't hear that.
When federal and state cases are parallel, as they are here, this case and the case that was earlier filed in front of Judge Ruiz are parallel cases. That's not what we've said. That's what the city said. And I think it's a telling point, because there's quite a lot of procedural jockeying here, and we'd say game playing, and it leads me to a point that I want to make sure to address with Your Honor very much head on, because it was such an important theme in the city's presentation. The city opened by saying that everyone on this side of the courtroom wants to avoid Your Honor, that the objective is to avoid this court. The claim that I heard was that the people on this side of the courtroom don't trust this court, don't trust Your Honor. Your Honor, that's wrong. It's 100% wrong. It's unfair and it's unreasonable. We trust you. We trust this court 100%. We trust the federal court and Judge Ruiz 100%. I'll observe that the charge that the first filed litigant doesn't trust the second court is exactly the charge that one hears every single time the second filed litigant, such as the city here, says when it's later called out on its procedural game playing, and it's done to deflect from the law, and it's to deflect from the game playing, and it's designed to justify what the party in that position always wants, which is a procedural mess. And that is what is sponsored here, Your Honor, a procedural mess. Instead of having one court that can address all of the issues in these parallel cases, the first filed claim in front of Judge Ruiz, the city wants two. We're not trying to keep anything away from Your Honor. We're asking for a stay because there's an earlier filed case that will take care of everything. I'll get to that in a minute. It will take care of all the issues here in front of Judge Ruiz. It was first filed, and it is the right court for the disposition of the federal constitutional issues that lurk behind every aspect of this case, notwithstanding the city's claim, which we think is plainly inaccurate, that what we're dealing with is a landlord-tenant dispute. Your Honor has heard from Mr. Wilson that Ohio law and federal law all point cases, direct cases with constitutional issues towards the federal court. That's the law, and that's why we filed there. And you kept hearing that we filed our complaint on Memorial Day. Well, not really. We moved for leave and presented a complaint in March. And the city wouldn't consent to that leave to amend. It filed an elaborate motion opposing it, even though it's a routine motion, and that had to be briefed. And Judge Ruiz was compelled to, and did, issue a reasoned opinion disposing of what was a plainly meritless delay tactic. And we're told that we're trying to sponsor a procedural mess. Please, Your Honor, we wanted to make clear what's happening in the federal court. After leave to amend was granted over an objection subject to a 4-page reasoned opinion that Judge Ruiz wrote, the city moved for reconsideration of an order allowing an amendment to a complaint very early in a lawsuit, and it sought interlocutory appeal to the Sixth Circuit Court of Appeals. Your Honor, not only couldn't we find a case that had granted such relief, we couldn't even find another litigant who had sought such relief, because, as Your Honor knows, leave to replead early in a case is freely granted. And yet, this has turned into a battle line like Verdun in the federal court. And why is that? Because what is on offer from the city is every effort conceivable to avoid joining issue in the federal court where the constitutional issues belong and where the case was first filed. So with enormous respect for Your Honor, we won't stand by to the subject that we are trying to avoid a court, because there's one party that is frantically seeking to avoid one judge, and that is the city trying to avoid Judge Ruiz, who has this case properly, who has now said he is going to entertain the further amendment complaint, who has devoted time and judicial resources in disposing of the meritless motion practice that my friends on the other side have entered into, and where the case was not only first filed, but where the constitutional issues belong. If it ultimately should come to pass that, for whatever reason, the federal case did not dispose of this claim, the first filed action didn't, we'd be delighted, Your Honor, to be back in front of you. That's why we ask in the first instance for a stay rather than a motion to dismiss. Mr. Herdman told you the various things that he hasn't heard of. It is entirely conventional to seek a stay in these circumstances rather than a motion to dismiss, because if it should come to pass, and I don't think it will, in these parallel actions, we're happy to be in front of Your Honor. But the claims here are all in front of Judge Ruiz, and they should be disposed of there. I do want to just, the idea that these claims aren't overlapping cannot be taken seriously. It's been admitted. It's plain as day. Nothing in the federal case will resolve absent of the disposition of the constitutional claims and the contract claims. I do want to address what I think is a little bit of interesting maneuvering with respect to this allegation that the Browns are in breach of the lease and that has been properly alleged. There is a pleaded claim having to do with breach. It's a claim for anticipatory breach. And what it says is that the Browns are in breach of their lease. And you've heard over and over again from the city that the Browns are in breach of their lease. We're trying to sort that out. The Browns have a lease. They have to pay rent. The Browns are paying rent. The Browns have upkeep obligations. They are meeting their upkeep obligations. The Browns are obligated to play all their home games in Huntington Bank Field. They are playing all their home games in Huntington Bank Field. Every material of that term is of that lease is being entirely complied with. Now, the theory of the complaint is that there's an anticipatory breach. And Your Honor, the reason we're told it's an anticipatory breach is because the team is considering whether to continue to play its home games in Brook Park after the lease expires. That is true, but it's not a breach. And it's plainly not a breach. And the only way you can know if it's a breach is to decide whether the Modell law applies. And this is why the claim of anticipatory breach as pleaded, which relates, as Your Honor saw, entirely to the compliance with law provision of the lease, is a complete bootstrap. It is simply the constitutional question masquerading as a lease term. You can't know whether that pleaded breach of the lease is a breach or not without deciding the federal constitutional claim. Pure and simple, you can't. Mr. Herdman said, well, you might hear from the other side when they stand up that they haven't pleaded other violations of the lease that are set out in Section 9B of the lease. He said, well, they might say there's a technical pleading failure, but technical pleading failures are readily resolved by an amended pleading. Would that were the city's attitude when it was on the other side? But let's leave that to the side. Mr. Herman forgot to tell you something really important about Section 9B of the lease, that every single provision that he cited spoke about obligations that exist only throughout the term of this lease. That is to say, they expressly fall away when the lease expires. And every one of the purported claims that we'll see in this hypothetical amended complaint have to do with things that will happen after the term of the lease expires. They can plead it, but it will be as meritless as the anticipatory breach claim. You heard a little bit about the pre-court decision. That was the one involving the Columbus soccer team, the Crew. It's really important to emphasize this point. That case and this case were different in the way that matters. The Modell Law was passed, and everybody knows it, so that a team that tried to move away from an Ohio taxpayer-funded facility during the term of its lease, because that's what it says, has to comply with certain restrictions. That's what they did in that case. That's what Modell did. Same thing. But this is completely different, because the Haslam Sports Group has said over and over and over and over again, it will honor that lease. It will pay its rent through its expiry. It will play all of its home games throughout its contractual obligations. It will not do what Art Modell did. It will not do what Art Modell did in the sense that it will honor its contract, and it will also keep the team as the Cleveland Browns right here in the center of the Cleveland metropolitan area. The Crew wanted to move the team to Austin in the middle of the lease. Completely different. And that oughtn't be obscured. Some distinctions are little, and some distinctions are the difference. The distinction here, Your Honor, is the difference.
So you're saying that the Modell Law, you can only violate it during the pendency of a lease?
I think, Your Honor, that I wouldn't want to make quite as broad a claim as that, because there might be circumstances that aren't presented in this case that would implicate that, and you're asking me for a general articulation of a legal principle. What I'd wanted to emphasize, Your Honor, is that the lease itself has many provisions that exist only throughout its term, and that provision should be respected, and that the Modell Law's plain words and purpose are designed to ensure that a team that plays in a taxpayer-funded facility or property will respect its agreement. And the agreement, of course, is the lease. Please, Your Honor, recognize how extravagant the position is on the other side. Their position is that a lease signed in 1996 with a 30-year term, and that requires at the end that the Browns peaceably surrender the leasehold, and that obligates the city not a bit, to extend the lease or improve the facility, keeps the Browns in that facility forever. That's not the way contracts work. It's not the way the law works. It's one of the reasons that the interpretation here is plainly going to be held unconstitutional when a federal court has the opportunity to look at it, which will be soon if what's happening in front of Judge Ruiz is any guide. I wanted briefly, Your Honor, to address the charge from the city that the Browns rushed into the federal court. Your Honor, that's just really not, it's just not what happened. And I think Ms. Reddy laid out the facts this morning, but just to make sure, the city had been threatening enforcement of the Modell Law for 5 months before the Browns sued. And the city and the Browns have been trying to work with the city to figure things out, and they kept threatening this enforcement for 5 months. And they passed an enforcement ordinance in May 2024 saying, go ahead and sue the city. The Browns didn't sue for 5 months until October 2024. It isn't true that the Browns rushed in. The Browns actually were exceedingly patient and tried to avoid it. But when it became clear that to have any sort of clarity about the path forward, it was going to require judicial relief, the Browns took their lawsuit to the court that is best equipped to resolve federal constitutional issues, which are going to be key here, and that was the Northern District of Ohio. As for the claim that the city is the natural plaintiff, we beg to differ, Your Honor. Pre-enforcement relief, as I believe Mr. Wilson went over with Your Honor in some detail, is the preferred remedy for the disposition of federal constitutional claims where a harm to a private citizen is threatened. It's the natural plaintiff in the pre-enforcement context, and this is the United States Supreme Court talking, not just some lawyer yakking at you. The Supreme Court said that the pre-enforcement litigation route to a federal district court is the preferred route. That's what the Browns did. They didn't rush and they didn't forum shop. They took their time, tried to work it out, and then went to the right court timely. As for suffering no harm, I mean, the city, being clear here, the city is brandishing the sword of Damocles. Do what you think you must, do what you want, but we're going to come in at a time of our choosing, and we will wield this sword. We will harm you. We will dismember you. The person over whom that sword is being wielded are the Browns. And the Browns, after trying to work it out, said, that's not going to do because we have important decisions to make for the team, for the players, for the fans, for the city, for the state, for the county. And they took that question to the right court. Now, the city could have sued. It had authority from May 2024, but decided not to. It decided to try to beat up on the Browns, to threaten them with the sword of Damocles, and the Browns did the right thing, finally seeking a remedy, and now they are charged with avoiding Your Honor. Your Honor, the opposite is true. The opposite is true. Finally, I wanted to say a word about abstention. The city does not address a matter that I think was quite clearly articulated in our papers, that federal law now disfavors abstention, and it advocates certification to a state Supreme Court as the proper remedy when the federal court believes that guidance would be necessary. Abstention doesn't work in this case because you can't just reserve your federal issues, and from a procedural perspective, we suggest that our friends seem to be proposing something that is as unwieldy a contraption as one could imagine, where the state law claims would be addressed in front of Your Honor. And if I understood Mr. Herdman right, he was saying, well, we'll come to this court, we'll litigate those claims, and if they lose, case is over. And if they win, then we can go to Judge Ruiz later, figure out whether the Constitution applies. A few things on that. First of all, that is exactly why supplemental federal jurisdiction exists. Second of all, it's completely contrary to every principle of judicial economy that one could imagine. 2 judges, 2 courts, 2 proceedings, as opposed to 1 judge, 1 proceeding, 1 court. No excuse for it. None proffered. As to the point that the federal court cannot grant complete relief, completely wrong. And it's not only inconsistent with what is being suggested by the other side to the federal court, it's inconsistent with everything that one knows about supplemental jurisdiction. Indeed, these claimed breach of lease claims are not only obviously not appropriate because they are either a bootstrap on a federal claim, the one that's pleaded, or completely incognizant of the contract, the ones that apparently we will at some point in the future see. But whatever it is, they are part of the same nucleus of operative facts which make them evidently an appropriate candidate for disposition in a plenary proceeding in front of Judge Ruiz, who is the first judge seized with jurisdiction, is the first judge now to have issued a written opinion, and who is bringing everyone in front of him to get a schedule together. And for all those reasons, Your Honor, we think the outcome here really is plain. It's that this case should be stayed as a second filed action in favor of the first filed action in front of Judge Ruiz. If there is some reason why that action does not dispose of all these claims, seems unlikely, but it's possible, Your Honor will retain jurisdiction. But to have this case go forward, and I've heard that discovery is happening in this case, we don't really think that's true, Your Honor. It's true some papers have been served, but they were just of a record-making character. No discovery's been had. To have this case go forward and another case go forward at the same time with the same issues is exactly what the stay device is designed to achieve, and exactly what the rules of procedure we've invoked in this court and the federal court are designed to avoid.
What was the nature of Judge Ruiz's written opinion?
He wrote a 4-page opinion granting the Browns' application for leave to file an amended complaint and rejecting the arguments that the city had offered in opposition, including the proposition that the amendment would be futile. He said that could be disposed of later. Implicitly, we think rejecting the jurisdictional claim that had been offered, and I think that's why they are challenging that on an interlocutory appeal, which
Did you
will...
speak directly to the jurisdictional?
I think, what did he say about jurisdiction? Yeah, I think he did, Your Honor. It's in the papers. Well, why don't we actually have a look at it?
It's a short opinion, he referred to the pages.
Sorry, I didn't hear you.
Judge, I just suggest you read it for yourself, and you could, I mean, if you'd like, it's 4 pages. Our position is he didn't address jurisdiction, their position is he implicitly addressed it. I would just, it's 4 pages, we'd be happy to provide you a copy, but.
Okay, that's fine. I just wanted, if you could bottom line it, did he say the jurisdiction was established in federal court?
I don't think he said quite that. He rejected, let's be clear. I find apparently this is entertaining to the other side. As a part of a campaign to avoid federal court review of their federal claims, the city objected to the amended complaint on the ground that the motion for leave was not jurisdictional. That was their argument. It was rejected. So there's no way that does not reflect a decision respecting jurisdiction. Moreover, they are trying to take the question whether Judge Ruiz had jurisdiction to the Sixth Circuit. And I guess they think it's funny that a case can be delayed on the basis of obviously meritless game playing in the federal court, and then come before this court and tell you that it's someone else playing the games. It's just not the way it's
And
happening.
what's the nature of your case management conference that's coming up? If you can say.
We understand that the court will at that time set down interim dates leading to trial for discovery and motion practice. It'll be up, of course, to Judge Ruiz to decide what he wants to address at that conference. It was put down for July the 17th, Your Honor. We've moved it at the request of the city, and we think it's going to happen a little bit before then, and we expect to have a full schedule of proceedings through discovery into trial. At least that's what we're going to request, and we understand is likely. Your Honor, I'm mindful of the time. I'm sure my friend will have some words to say. If you have any more questions, I'd be delighted to try to answer them.
Do you know of any other litigation that is pending in both state and federal courts at the same time?
You mean?
That's not unheard of, right?
I don't think it's unheard of. We have, and I personally, as an advocate, I wouldn't want to start testifying, Your Honor. We have very often had the occasion to seek to stay litigation in a federal court or a state court when there was prior pending litigation. In many jurisdictions, there's a statute that governs that situation. In every jurisdiction, as in this one, there is a body of common law that favors the prior pending case. It happens pretty frequently that for whatever tactical reason, one litigant or another prefers one jurisdiction or another. Sometimes it's one state court and another state court. Sometimes it's one federal court and another federal court. Sometimes it's a state court and a federal court. We've seen it happen.
So this is not unusual?
It's not unusual for the filings to happen, but I'll tell you it is unusual for the second filed case not to be stayed, because that's the natural way to dispose of the problem. No judge, in our experience, thinks it's appropriate to have 2 cases pending at the same time, so they work really hard to avoid that outcome, usually by staying the second filed case, which is the relief, Your Honor, we're asking from you.
And you're saying that applicability of the law has to be determined after the constitutionality?
Essentially, the claim that's been pleaded is that there's a state law claim that says there's been an anticipatory breach. The reason we're told that there's an anticipatory breach is because the Browns had to comply with law. The noncompliance with law is the noncompliance with the Modell statute. So that's why I said, Your Honor, it was in the nature of a bootstrap argument. It all comes back to the Modell law. Now, the Modell law litigation is going to have several aspects. There are three significant constitutional infirmities to the law. There also are issues pertinent to statutory construction. So all of those things need to be decided. I wouldn't want to leave Your Honor with the impression that it is only the federal constitutional issues that need to be decided, but it is certainly right that the case can't be disposed of without addressing those matters which belong in a federal court.
And just for the record, the city has not consented to the move.
I'm sorry, Your Honor?
Just for the record, the city has not consented to the move. Is that right?
We have not.
Okay.
We've not
And-
agreed to it.
And
Okay.
you mean the move to Brook Park?
Yes.
Oh, yes.
Yes.
Okay, and just for the record, there's been no good faith offer to sell the reasonable.
That's correct.
That's correct. And just, I know Mr. Wilson talked about ripeness as it relates to the motion to dismiss. Did you want to say anything else about the ripeness of this?
I will, and thank you, Your Honor, for that suggestion. I don't want to belabor the issue unduly, and I think we've addressed it in our papers. I think the city's argument boils down to the argument, and I'll give them this as a certain amount of common sense appeal, that we're saying this case isn't right, but the federal case is. And we do say that. That is our position, and we think it's a principled position. We think
It's a what?
it's a principled position. We think it's a
Principled position?
and it's a correct position, and here's why. The claim in this court is one by the city that is seeking essentially a pre-enforcement answer to whether it can act. We are also seeking a pre-enforcement decision as to whether the city can act, whether we can act. This is a pre-enforcement, the pre-enforcement constitutional challenge, the pre-enforcement interpretive challenge. There is only one party who is harmed by the uncertainty, and there's only one party that has standing to pursue that claim, and it's the Browns. Put simply, it relates to the metaphor I was raising, Your Honor, about the sword of Damocles. The ability to bring a pre-enforcement challenge does not rest with the party brandishing the sword. It rests with the party who might be stricken by it, and that's the Browns. And we think that distinction is really quite clear in the cases that we've set out in our papers.
Okay, so you're saying that your client does not have a sword?
Yes, we are saying that, because the relevant authority here is whether the city can exercise its regulatory authority to punish or discipline or litigate against the Browns. It is, the reason for this doctrine of law is to stop private citizens, to give private citizens an ability to challenge threatened regulatory authority so they don't have the dilemma whether to either not act when they wish to and believe they ought to be able to, on the one hand, or act and risk a regulatory reaction on the other. It is a body of law that exists to give citizens the right to get clarity as to the scope of government authority. And that is the claim that we are raising, and it is ripe. It does not exist to give the city the ability to determine its own authority. That is a pure advisory opinion and accordingly unripe.
Okay, and by private citizens, you mean the Haslams?
The Haslams and the Browns, that's right. That's right. Non-government actors.
All right,
Your Honor, thank you so much.
thank you.
I will be brief, Judge, thank you. I just want to start off this idea that we have somehow conceded that because these are parallel proceedings, that they are the same. Those are two totally different things. I was driving into work pretty early this morning. I drive a Tahoe. At one point in time, I think I was parallel to a Vespa, but those aren't the same things, okay? So parallel is not the same, okay, Judge? I mean, we are talking about two different cases here. And the other thing is, there's some attempt to blur the lines here between what's in the lease and what's in the Modell law. And I would just suggest to the court, please look at the Modell law. There's nothing in there about a lease, nothing at all. It doesn't mention a lease. It's absolutely neutral when it talks about a lease. And it's obvious why that would be the case. Because the Modell law talks about two things. It talks about notice, and it talks about opportunity to purchase a team if there is not an agreement by the city that has funded the stadium that the team is playing in. Doesn't care about the lease. The statute is absolutely neutral when it comes to a lease. Now, the lease is not neutral when it comes to the Modell law, and the lease is not neutral when it comes to whether or not the Browns are playing in the city of Cleveland. And, counsel pointed to the lease provisions, and he says that the very important provision in this lease is in section 9B. And I will read it again for the court. It says, obligation to maintain franchise. Lessee represents that it shall be, as of the commencement date, a member in good standing of the NFL, and agrees that throughout the term of this lease, it shall, so throughout the term of this lease, we agree, it says that, throughout the term of this lease, it shall, section 2(2), throughout the term of this lease, it shall not negotiate with any person or do or suffer to be done anything which will cause such rights, that is, the rights to play home games of the franchise at this new stadium in Cleveland, Ohio, not negotiate with any person or do or suffer to be done anything which will cause such rights to be lost or impaired or diminished in any respect, or transferred, relocated, or otherwise moved. Throughout the term of this lease. So, what is exercising an option on 176 acres of land in Brook Park? What is going down to Columbus and spending plenty of time down there talking to the legislature about funding? What is asking the commissioner of the NFL to go to Columbus to visit the state legislature with you? What is putting together schematics and drawings and gee-whiz drone flyovers of a proposed Brook Park stadium? What is having weekly officials with Brook Park City, weekly meetings with Brook Park City officials? Everything, I mean, you saw plenty of slides about all the activity and all the things that are underway in Brook Park. All of that is in violation of this lease provision. Throughout the term of this lease, we don't have to wait until the end of the lease to be able to point to this to the court and say that they're in breach right now. And again, that has nothing to do with the Modell law, has nothing to do with a federal constitutional claim, has everything to do with us being a landlord and our tenant being in breach. And when you think about why this is in there, Judge, it's because of what they pointed to with respect to Art Modell. Everybody wants to go back and talk about what Art Modell did in 1995. This is exactly what Art Modell did. He was negotiating with the city of Baltimore behind the back of the city of Cleveland, negotiating for a new stadium in Baltimore. And whether it's a perfect analogy or not, this is what the lease says. This is the lease that they are the tenants in this stadium. This is the lease that they are subject to, and this is the lease that they keep claiming they are not violating, that they are completely complying with. Well, guess what? They're not. And that's, again, why we're in this court seeking redress of our claims and seeking relief for those claims. And there's not a thing that the federal court is going to be able to do to address these claims, Judge. This is not a federal constitutional issue. There's no federal constitutional claim that's going to affect this. This is a contract claim. This is a breach of contract claim. That's why we're here. That's why we're in common pleas court. It's a breach of contract claim. Happens all the time in this courthouse. Walk in and out of this courthouse all the time with breach of contract claims. That's exactly what this is. And that's why we're here in front of you. This whole issue about abstention and certification, that's all being argued in federal court. That's all pending. We have a motion to dismiss there. That's all going to be decided ultimately by Judge Ruiz. And when that will be, I don't know. There's all this attempt to predict when that's going to happen. No one knows the answer to that. I'm not going to try to predict it. I'm not going to try to predict when that's going to be done. I'm not going to try to predict what sort of schedule we're going to have when we have our case management conference. It sounds like in a couple weeks. The bottom line is, we're here in front of you. This is the second time we've been in front of you. There's an interest in moving this case forward, and we are trying to schedule we are trying to move our discovery schedule forward with the opposing counsel. Let me leave it that way. Because we have discovery out, we've gotten responses that we need to follow up on, and that we intend to follow up on. So it's not just some like paper exercise. We actually, we put a lot of thought and work into our discovery that went out. And again, I'm not going to trouble the court with the responses that we got. We're not at that stage yet. But we'll continue to work it with the parties like we would with any other kind of discovery dispute. But we're working discovery in this case, Judge, and it would be a shame to stop that right now on what is a standard state breach of contract claim, coupled with an enforcement claim of a Ohio state statute, the Modell Law. All of this is together in front of the court. There's no reason to stay this, absolutely none at all. And again, that's why we're asking for you to deny their motion to stay, but put us in a position to continue to move this case forward and allow us to be in a position to swiftly resolve this. It's to the benefit not only of the city of Cleveland, but I also would submit it's to the benefit of the Browns. Let's get resolution on this and do it as quickly as possible. And put us in a position where we can adjudicate all of these claims and seek the relief that's available to us. That's what we're asking the court for. Thank you.
Thank you. This matter will be heard and submitted. And we'll have Ms. Nielsen continue to communicate with you all, and we'll let you know when the decision has been reached. Anything else? Oh, can I have a copy of that 4-page decision by Judge Ruth?
Your Honor, we'll submit it to the
Okay.
chambers promptly. And thank you.
Okay, thank
And the only thing I wanted to add was thank you and the court staff for the time and attention.
Of course, thank you all.
Thank you.
All right, you guys need anything?
Nope, just want to say thank you. You know how hard you guys work.
Thanks. Okay, all right.
Appreciate it. Thank you so much. Yes. Pick everything up.
Which one are you?
You know the Pina Colada song, I'm Getting Caught in the Rain? That whole song was just playing in my head the entire way through.